A pleasant day and a warm welcome for the program Law and Order. We all know that we discuss legal issues and giving you solutions for that particular legal issues and certain ideas that you need to encounter to survive in this environment. So ladies and gentlemen, we were discussing about many interesting topics and disciplines, and today we're going to discuss one of the most important areas with regard to money lending, because we personally lend money, and even with some institutions we have transactions and so on and so forth. There are many issues related to money lending, and to do the honors with us we invited Mr. Ian J. Fernando, Senior Counsel. So thank you very much for joining with us with this program. Right, okay, so today we are going to discuss about money lending, which, as I said before, which is a most important area that we deal in the current context. So simply, what is money lending?
Money lending is of different types. You can lend money from a third person, or you can lend or borrow money from the bank, or you can lend and or borrow money from a non-financial institution such as not a bank but a finance company. And also you can borrow money from a foreign currency company with the permission of the central bank.
Right, that means banks, the other foreign companies and other financial institutions, are they only the particular institutions that are like being given the authority to lend money?
Yes, there is also a professional money lender, is the third party. He has to formulate himself under the provisions of the money lending ordinance, and he should be within the framework of that ordinance once he lends the money.
Right.
For example, if you borrow 1,000 rupees from a money lender, a professional money lender who is registered, he cannot charge interest more than 1,000 rupees.
Right.
So the interest can't exceed the principal as set out in section 5 of the money lending ordinance.
Right.
Whereas in the People's Bank Act and the Bankruptcy Loan Act, the provisions are different. They can collect money on compound interest which will exceed the principal of the money that is lent, because in the statute itself it is empowered that they have the right to do so.
Right. Is that the way that particulars are operated, or is there any other formality that it is being operated?
The other formality is that money lent is by the money lender on a promissory note, on a check sometimes given for security,
right,
on a bills of exchange and items of that nature, negotiable instruments as you call it. Money can be lent by a money lender.
Right.
Now we have seen the money lenders who are lending money should, according to section 8 of the money lending ordinance, keep proper books of accounts, and that you should be regularly notified, like the bank sends you a statement of how much money you have given and how much interest you have paid and what is the balance that is due, which we don't see now in society.
Right.
Plus, when the money is paid, according to section 9 of the money lending ordinance, one must issue a receipt for the person who borrowed the money, to say that he borrowed the money and this money is now paid.
Right.
So
yes, sir.
There is also the provision of bills of exchange and the promissory note.
Right.
The promissory note should necessarily have certain ingredients. How much money was taken, what is the interest component, in how many installments it's to be paid, and what the time period is, and signed on a stamp which is 1 rupee per 1,000. So if you are having 10,000 rupee agreement, then accordingly 1% of that we go as a stamp duty on the promissory note.
Right.
If you do not put that particular stamping value on the promissory note, according to Act number 1982, Act number 43 as amended, the Stamp Duty Act, in section 33(1), once the document is put to court and evidence is to be laid on that document, you can say that the document is inadmissible because it is not stamped properly. It has to be stamped. So that was decided in 79 new law reports in part 2, wherein the Justice Ismail at page 105 of the judgment, more fully described at page 108, set out the law that if a promissory note is not stamped, it is not admissible, but however, you can formulate it once again by paying a penalty. So normally it's not more than 3 times of the stamp duty value that you should pay as penalty. That loophole in the law was given.
Right.
Subsequently, in Silavati's case, Srilata's case, it was also contended that if a document that is not properly stamped, say a receipt, right, a rent receipt is not properly stamped, is also inadmissible, but however, that defect can be cured by going to the Inland Revenue Department and paying somewhat a value, say 3 times the value, and then it can be brought to court, and the inadmissibility of the document will then move away and you can sue on that document.
Right. So as I said, like with these explanations, it's very much clear that if a person is going to lend money, he should register himself and follow the proper formalities, otherwise he is not a professional money lender. So in that case, sir, like there are many informal situations that the society deals, because like formally to register themselves and maintaining books is like a bit of a burden, because these days there are many cases like some people lend money, sometimes millions of rupees, they are going to charge huge interest rates, and as you said, like it might exceed the doubled value of the particular lended amount. There are certain informal ways. So and the money lending institutions, they are regulated by proper legislature, and but the professional lenders, they do have to adhere certain circumstances, but these informal people have set a burden to the society, because like it becomes like a certain sort of a disadvantage to the part of the society and leads to certain a crisis situation, and informal lenders have simply caused a trouble and a burden. So there is a proper way to regulate those things. So what is the importance of regulating those things in the view of a senior counsel?
Yes, now I give you some examples. For examples, what you say that we must regulate, we have conditional transfers. You own a property worth 1 million,
Right.
and you conditionally transfer it to me and obtain 500,000 rupees from me. Now that conditional transfer, sometimes when the money is paid, the owner of the property doesn't want to release the property. Then you have got to go to court and get specific performance that you have paid the money and to get the property released. So the law can certainly develop in that area. And we also see that they have written the deed not on a conditional transfer, they have written the deed on an outright transfer. Then you can show in court that the value, according to the valuation reports that you have taken, that the property is 1 million. So I could not have transferred it for 5 million.
Yes.
That's out, and the principle of liceo enormis will come in, where it says that if you have transferred the property less than more than 50% of the value of the property, that transaction is void.
Right.
So that is one area in the law that can be developed. The other one, you talked about the money lenders. The money lenders, of course, if they contravene the law, there aren't very many people to see that they are not following the provisions. So you will have to get some government authority to check on that, and if they have lent money outside the scope of the Money Lending Act, then they should be dealt with in the Magistrates Court.
Right. So Money Lending Act is the only piece of legislature that deals with this scenario, or are there more?
Regarding money lending, it's in that way, but if you take the pyramid system, according to the Banking Act, Section 83C, that's a pyramid system of lending money or accumulating money, which is taboo or which is prohibited, is the other act that will come into play other than the Money Lending Act.
Right. Okay. So in banks, like official and like a particular institution which like we can keep faith and we can trust, so they lend money in the form of loans, a lease and some other scenarios, so we all know, and they charge a reasonable amount of interest for their flow and to maintain the stability. But like we have seen people, although they might be professional lenders, they sometimes charge a huge interest rate, sometimes which might seems unreasonable. So is there any regulation on the interest rate that?
Yes, when you are a money lender, as I mentioned, the interest can't exceed the principal. Whatever it is, whatever regulated rate you have, the interest can't exceed the principal. So you will have to formulate your agreement or your understanding with that person on that basis.
Right.
Some of the money lenders take a empty check signed by you and use it as security.
Right.
And if you have not paid that money, they might sign, they might fill up that particular check and present it to the bank and get the dishonor endorsed on it, and then file action for you to pay back the money.
Right.
However, if you have paid back the money, there is no issue if you have got receipts from the money lender.
Right.
Otherwise, after he has got his full amount of money, he will go for some more by putting that check in,
Right.
the undated check that you have. So you can show from your checkbook folios and the dates that this is an undated check.
Right.
Undated checks are not the proper form of business. Mr. N.E. Veerasurya has set out in his book on banking, where he says that people use undated checks, but that is not a proper way of doing business.
Right.
Also, I must state that when there is an undated check, sometimes you might have closed your account, not knowing or forgetting the fact that you have given an undated check.
Yes.
Then he will present it to the bank and you will have a very big problem on your hand, where you will be sued by him under section 25(1) of the debt recovery law, which says that if you issue a check without funds in the bank, or issue a check without knowingly that there is no funds in the bank and you have closed the account, you are liable under section 25(1), which is quite a grave offence. So the only defence you can take up if you are under that section 25(1) is that you did not know that the bank has closed its account, or that you didn't envisage him to put this check in because there was no necessity, you had paid all the money, and or that you have given this check only for the purpose of security, and if he was asked to bank it, he should have got your permission. So those are some of the defences under section 25(1) of the debt recovery law that you can state. Possibly if the bank has closed down your account and notified you, but the notice has gone to your previous address where you were staying, and you did not know, and in the present address you have issued some checks, then you have not got any intimation that the check has, that the bank account has been closed. Then in such cases you will be liable.
Right.
For examples, you get sometimes banks sometimes make a mistake of having the checkbook number wrong,
Right.
or the account number wrong. So you will issue about 2 or 3 checks and find out that these checks are not going in and the account number has been printed wrong.
Right.
So in that scenario, if you are asked under section 25(1) that there was no money in the account, you can always say that it's the wrong account that was printed on my book and I did not see that.
Right. So
Can
there
take
are
the defense.
certain consequences that we can discuss, and like sometimes might be loopholes, sometimes might be certain tactics
Correct.
used to avoid them. Right. In certain cases, like you explain with the principle, that means if we were lended 1,000 rupees, the interest must not exceed the same amount.
Correct.
That means, is it at the end of a particular year?
At the end of a particular period. For example, if you are having a contract for 6 months,
Right.
and you are charging 20% interest,
Right.
you will see that it will be within 6 months, it will be paid 1,200 rupees back.
Yes.
So then that other 200 rupees is illegal. He has no
Right.
legal right to collect that money.
Right.
You see that many happening at the various police stations where money is lent and advanced, but apparently the officers of the law must be educated that you cannot take more than what is there in the principal when you are a money lender.
Right. Okay. So that's what we were circulating, because like most often people like, this is for a period of 1 year, I'm going to charge 10% monthly interest rate. For example, 100,000 is being lended, although it is calculated based on the simple interest rate, it will exceed 120,000. So that particular 20,000, even though it is calculated the simple interest mechanism, that is illegal, and compound it's somewhere around more than 20,000. So sometimes it might be for a agreement period of 1 year, 10% is also exceeding that particular principle. And if they are seems to be professional lenders saying that we are charging this amount reasonable, it's not right.
Now Charita, I want to also mention, you mentioned about checks. When you are giving a check and the check is bounced, there is a duty upon the person who had received that bounced check to give you a notice of dishonor, stating the reason why the check was bounced.
Right.
If you go into court without giving that notice of dishonor and or a letter of demanding that money, your action in court will fail.
Right.
And also on a check, there is a particular prescriptive period. If you have a check which is over 6 years stale, then you cannot go to court because you have passed the prescription period.
Yes.
Also, if you have a simple money lending transaction according to the principles of the Prescription Act, your money lent in advance has to come within 3 years from the date of issue. If you go in 3 years after, on the prescription point, you will be debarred from going through your action. However, if you have a money lending transaction with a running account, the prescription runs from the last payment that you made up to a point of 6 years. So those are the principles that are necessary to find out when you are going into court on a money lending transaction, how you can construe your case and formulate your case in the particular court.
Right.
So we have what you call summary procedure in our civil law, where in a money lent and advance transaction, if a check bounced, you can go to a particular procedure which is faster and which is different from the regular procedure in law in our civil procedure code. There is, in the first instance, you can ask that a decree nisi be entered in your favor. If you have sufficient cause, then the opponent who has to pay you the money and where the check has bounced has to come and show cause for him to be able to file an answer.
Right.
If he is not able to show cause, then you will get the decree nisi made absolute.
Right.
And also we see in money lending transactions now, with the performance of the Electronic Act and the special provisions of the evidence ordinance, people record your conversation. So if you have borrowed money from someone and if you want it to be notified, there is no written document, you can on a voice recording get it admitted that the money was taken by you.
Right.
And once you formulate that at the police station, you can play the voice recording if you are smart and say he has no defense, he has agreed to pay this money on these dates, but now he has defaulted.
Right. Okay, that is the scenario. And so, like with your practice as a senior counsel, you might have seen certain cases with its parate execution. So can you just explain this principle as well?
Parate execution was brought by the government of Sri Lanka due to the fact that so many people were not paying up their loans, and that's regarding property. So the parate execution moves in a manner where the board of the particular bank comes into a finding that you have defaulted payment and then seizes your property. And for that, the normal situation where you have to go to court and file action and seize the property is not there, you can straight away seize the property. So once that property is seized and that person has a difficulty, he has to come into court and say that they are not entitled to take the parate execution. Either the board resolution was wrong, or the facts and the figures in the accounts are wrong, or there was no proper proof of publication of the parate execution. There are certain legal defenses that you can take to stop the parate execution by getting an order in court. But in scenarios of that nature where the bank is involved, in cases of that nature, the court is very slow to grant injunctions restraining the bank from collecting their due money, because they are supposed to do a proper business transaction with their clients.
Right. Okay. So, sir, and another thing, sometimes people, so the professional lenders, sometimes the institutions, they are defaulting in keeping their records properly. So, what are the consequences?
You are talking basically of a money lending person.
Yes.
Yeah, if he is defaulting, then in court he won't be able to prove how much money he has taken and how much money he has given.
Right.
But as I said, with the electronic advancement in technology, in the Electronic Act that we have in Sri Lanka and the evidence ordinance special provisions, if you have some tape recordings or some video recordings regarding this monetary transaction and how much was taken and how much was given, you can apply that in court.
Right. So, no need to worry that we don't have written records.
Not necessary. And in a case of that, if you can prove that it's a business transaction, according to section 23 of the Electronics Act, you don't even have to give that 45 days notice and give a special list for it to be taken up in court. You can do a normal list, you can go to court.
Right. And so, like, what is the role of the mediation board in this relevant context?
So, on small claims, we have a small claims court in every province or in every jurisdiction, that's in the district courts. If it's less than 250,000, as I can recall, if there is any dispute regarding money, you can go to the mediation board and mediate how best the settlement can take place and how best the money can be repaid back to you.
Right.
If you fail in getting that from the mediation board, you are supposed to affix that particular order given by the mediation board, and then only you will get jurisdiction to file action in the civil court.
Right. And how about this arbitration comes into play?
Arbitration will come in the money lending transaction if there is a specific arbitration clause regarding the part of the money lending. Then you are allowed to appoint, each party is allowed to appoint an arbitrator, and each party can decide, those two arbitrators can decide who would be the umpire in such a case.
Right.
Arbitration is almost welcome in such cases, because the case will be heard at short periods of time and not necessarily in court, where it will take a long time to hear the case, and the result that you want of the particular transaction can be obtained faster than in court.
Is it a good way to adopt, sir, like moving to arbitration rather than courts?
Yes, because the arbitration is held by certain arbitrators, and they will be arbitrating on your matter, on some other few matters. Not that you are going to a courthouse which is flooded with cases, then you will have to wait for your normal turn to get your case heard and the normal postponement. Whereas in arbitration, you can have it that in a short space of 3 months or whatever it is, a clause that the arbitration must be completed, and therefore you can recover your money easily if there is an arbitration clause in your money lending transaction agreement.
Right. Okay. So, we discussed several disciplines and essentials with regard to this money lending, and the most important thing, sir, is that like I can have a transaction with you or a bank in rupees, dollars or whatsoever. But when it comes to the cryptocurrency, which the current society is dealing with, how this thing apply?
Cryptocurrency in Sri Lanka at the moment is not recognized. So, that's a taboo, and if you are caught in doing any act regarding cryptocurrency, like I said, the pyramid system is also frowned upon by section 83C of the Banking Act. Cryptocurrency, though it's taking part very much in the other countries, Sri Lanka has not given any leverage or any law also. Such acts are condoned and are prohibited in our Sri Lankan system of law.
That means transactions using crypto prohibited, or we can do, but if there is any trouble, no law to assist.
As you said, you can do, but once the trouble comes, you will be in double trouble.
Right. If there is a will, there is a lawsuit.
Yes.
Right. Okay. So, thank you very much, sir. We did a wonderful discussion on money lending, because these days people need money, people lend money, people transactions are involved in certain forms, but like in certain current day-to-day activities, we should be very careful in lending or in transactions using checks, promissory notes, and certain other cases. So we did a wonderful conversation with Mr. Ian Fernando, Senior Counsel. So thank you very much, sir, for joining with us with this program Law and Order. So ladies and gentlemen, this is Law and Order. As you all know, we're discussing many disciplines regarding law, so you'll be not letting in trouble when you know the surrounding circumstances and environment related to certain areas. So stay tuned with Law and Order. We'll be discussing more interesting topics in the future as well. Thank you very much for watching. Have a pleasant day.